1 second. Start with the very beginning.
Okay. The very beginning is on the screen. I hope you can see my presentation, everyone.
Yes.
And let's start with one short slogan, like a motto for today's conversation, for today's meeting, presentation, etc. Let me say it like you can build almost anything in weeks now with the help of AI, for example. So what actually stops someone copying you, I guess? So that's a real problem for many of us creators and developers, that our original product and our approach, our business is not protected anymore like it was organically protected, for example, 3 years ago, before the massive AI, era coming. And and probably you have read you read it before, that, for example, in 2013, as an example, a very short example, Snapchat, for example, launched stories. It was a very old, but very well-known story inside of the stories. And once they have launched it, Facebook offered about $3 billion to buy Snapchat after this launch, and they refused to sell it. And just after that, in 3 years, 2016, Instagram and Mark Zuckerberg, they have launched their own stories with Instagram after Snapchat. And just in 1 year, they overtaken all of Snapchat by this launch. So that is an example how important to not only to develop the idea and product, but how to protect it and how to not to be overtaken. Okay. Today I have been prepared for a long conversation. That is because I have an agenda. We can skip it for now. But the very important thing, according to the agenda thing, I need to say that we founders and developers should follow the one new and very modern rule in this regard. The rule, like before you describe anything or invent anything publicly, seal it first. With many other options, you can do it with the very organic and very natural way how you can seal your idea. You can sign NDA, non-disclosure agreement, with the customer or with the platform, with anything where you are sharing your idea. You can use timestamp with Bitcoin. It's free. You can use many other specifically built timestamps to seal your idea. But once you not sealed, your idea will be almost 100% gone.
Stolen, huh?
Stolen, gone, replicated, or somehow built by other people. Before we start with the longer story and other examples, let me introduce a couple of very necessary slides with information which shows the landscape of any intellectual property move to help us to navigate ourselves and our product inside of this kind of puzzle of laws and lawsuits and different codexes, government-based codex. I mean, not the platform. And once we have started with these, let me ask first: do you know what does it mean? Anyone here, do you know what does it mean? These numbers and these sentences.
Not really. Well, probably it's like from some type of a what's that called? A law.
Yeah, here exactly right. Here in the United States, I think every founder should know that that exists the very specific law, Codex number 35. It is issued by government, and this is a patent law, naturally, for the United States. Codex number 35. And it consists of many other things, but we should know just 4 of them for everyday use, which makes us protected once we follow these 4 kind of rule. The first one, once you are developing or inventing anything, you should be inventing something very specific and concrete, no abstract idea. So novelty, it should be a new idea and implementation in terms of the novelty, like an approach. It should be non-obvious. So you are not. If you want to be protected, please follow non-obviousness topic because once it is obvious, it should not be protected with the law, with the help of the law. And the disclosure should be disclosed once you are opening your idea, for example, on your website or with your App Store, application, or with anything like that. First, you should write down the disclosure of your idea to seal it for future with the help of I will say in a different on a different slide with the help of the specific documentation. But once you disclose something, and if you will be trying to protect ourselves, you should know how to describe your idea with the number of terms and conditions and other words specifically built with the help of a law to protect us as a founder or as inventor. We have a tremendously well-known 2 themes in this regard. One of these things were like Supreme Court rulings. These 2 things shows how the abstract idea, even with a great company, not helping to the company to protect itself, and after the court, they have lost the business. this was Alice Corp company, 2014 case. So you can see it on the side, on the slide, and that means that if your idea is abstract, it should not be so deeply abstract, and even court will not protect you if you will be suing by other companies for example, making the same business after you thought you are protected. And Mayo, the next case, they have lost the business because they were issued the kind of medicine which were working like a nature, like a law of a nature. You know, it helped to diagnose kind of blood disease, but it was built like a organically body itself, you know, behavior, and they were not succeed with their idea, and they lost their business as well. So the very important word, another one important word is moat in this business. Once you are building anything, you should be protected by a moat, you know, and it is not the moat like in a forest. It is an organically built moat with many tiny and technical things described by a company and described by your, for example, patent application, which makes your business described in a very unique way, piece by piece, tiny thing by tiny thing, which is your invention, which describes your idea, which describes what you do with your customers, with your technical stuff, but in a very unique and very specific way. Yeah, and the idea here is we are building moat to protect ourselves.
So no moat,
no protection, no protection. And it is like a shell around your business. Once you have built your description, once you disclose your business, you need to understand where your moat is and what it consists of.
Okay.
Here, a very simple and very well known thing, because many of the acquirers, many of investors are looking for the business which is protected already. I have many of such discussions in different ways in different countries, where investors trying to invest, for example, or buy the company, the share in a company. The first or the second question they will be challenging the partnership, the developer, the founder will be like, how are you protected? Do you have a patent? Do you have a provisional application or things like that? If not, and if you are in AI battle, probably you will lose your chance to gain these investments from the investor, because everyone can copy.
So if you don't have a patent in AI space, it's almost unreasonable to do anything then. First, you need to patent what you're about to build, and only afterwards you can build anything.
Look, I would say yes, if the idea is real, if the business is real, it will be copied, I think, during a couple of days.
Interesting.
Yeah, and you should be protected not everywhere, not over the globe, but you should be protected at the exact market where you are operating, for example, in the US. And once it will be copied, you will sue your clone or competitor in that regard with much higher rate of success.
Okay.
There are some practices over here. Three mistakes, which makes even large companies and large, group of founders. For example, some story about Blackberry.
Blackberry phone.
Blackberry phone. They lost their market leading position just in a couple of years.
Yes.
Yes, because of the mistakes like this. And
so they didn't protect their intellectual property, or what? Or they didn't know what's already taken?
Probably you know or not, Blackberry and Nokia, they have invented a touchscreen phone before
Apple. But they didn't patent it.
They didn't protect the idea, and they didn't prove the decision how to make it protected. They didn't make their Moat.
Interesting.
And these two companies, where they are.
But it also feels like if they protected their knowledge of how to use a touchscreen, it feels such a commodity right now that everything is a touchscreen. Did Apple patent that technology?
The answer, yes. But look, once the idea is obvious, or it has a prior art, for example, it was like a law before. Now it's different, but prior art law was a very powerful part for example, old-fashioned companies who started these builds in 90s, in beginning of 2000s. So it was like a law. Right now, the law is different. Right now, it's working like who first applied for a patent. Though this company will have an advantage.
So it doesn't matter if you were the first one any longer. It matters if you applied.
If you right now it works like this, but before this law has been implemented, it was a different law about prior art. So who got the idea first? Who got published the idea first? Those companies had the advantage. And the example I have been talking about Nokia, about the Apple and Blackberry. So it's about prior art first. So once you have many, you've been asking me, did Apple patented their touchscreen solution? They have patented Apple Way touchscreen solution. So it can be
Blackberry Way, Alexa's
yeah,
Way, Andrei's Way.
Yeah, it can be patented in many other and tiny and technical things connected to each other to protect not the screen itself, but to protect what is under the screen.
Under the screen, the technology. So what's technically protected here as intellectual property is the technology behind the screen itself and the fact that it responds to our fingertips.
And they have hundreds of patents in that regard. Hundreds of patents in that regard. This is their mode, literally.
Okay. So every little detail can be a separate patent, pretty much like.
For sure. And the mandatory part here, do your patent as narrow as you can. Because if you are operating or you are making your business in a very niche field, you should be protected in that specific niche firsthand. Of course, everyone is dreaming about how to patent everything around the industry. But it is not a realistic approach. You need to be much more specific and concrete with the idea to help to protect yourself using your niche business. Okay. And yeah. Now we are going towards to AI products. Right now, our founders built AIs. In many cases, it is not actually an AI. We are not building large language models anymore. We are not building like a new codex or a new Claude code, like a platform. We are building an orchestration of the different AIs with the help of many other things and layers and APIs, which makes your creative idea, like your website, which you have created just 1 hour before, it is built with many other things. You have not invented the thing. You have invented a solution. And the solution is how to orchestrate other things around your business idea and how to protect your business idea here in the United States with the help of a law. Because once you have described it and disclosed it, you can patent not the technical solution only, and it is not necessarily starting from now to patent, for example, code base. Nobody cares about your code base because it can be written with a different code, with a different language in many ways. And you will not be protected anymore. But you can, under the law in the United States, it is a unique country over the globe. You can protect the business idea. You can lay out your idea with number of rules and things being orchestrated, and that will be your AI solution.
Okay.
Understand?
Yes.
Okay.
Follow up with that. So if you come up with a service or products and you use an AI tool to help develop that, Claude or OpenAI, they don't own those ideas if you turn that into products. Where's the legalities when you develop products or services?
Well, usually you are using an official API, for example, an official license for using that specific tool, and that makes you protected in terms of the business because they have launched their platforms, like you know, the very first principle here is open source, like an open source business. Once you have open sourced your platform with number of tools, everyone can connect and use it legally. But it doesn't mean this other guy will not be protected if he will invent his business with the help of this tool, but like an embedded thing. The business itself is not about the tool, it's about his project, approach, idea, solution, whatever. So the approach and solution you can patent. The tool inside, from the inside, you should respect your business partners and your kind of platforms where you have taken an API, for example, or a tool. Okay. And here we are, a concrete technical improvement. So we can say that an abstract idea done on a computer, for example, fails. You know, you can describe any abstract idea, it will be very nice and very wide, you know, but once it is abstract, it will fail in terms of the law. But a concrete technical improvement, for example, which improve somehow the way how to do business, how to service your customers, how to make your search engine optimization, everything. This can be protected, and these kind of ideas survive.
So as a general idea would be, I have an SEO process that optimizes pages, and the patentable idea would be if you click A, then B happens, or like there is a specific algorithm, for example, that optimizes SEO in one click or something.
If you have a unique way how to optimize your SEO, it will be protectable idea. But you need to check it first. And that is why I have launched my platform for intellectual property, FITTIN.dev, because it helps to other founders and other creators to check the idea first in terms of this legislation, in terms of these principles, in terms of the non-abstractness, non-obviousness, and it will provide anyone for free with a specifically built document which will describe your idea in terms of the law. Will not necessarily talk to your patent attorney, and will not necessarily to start spending money once you are trying to diagnose, once you are trying to check your other hypotheses.
Okay.
Okay. Here we can my first idea coming to the session today was to play in a kind of a game with my platform, with our platform, because you can. It's up to you. I'm looking for your advice. If you like the idea to open your laptop and to open the platform, we can start with checking any idea, not specifically your business idea, but we can create it from the scratch right now. And you will see how helpful it will be and what the documentation will be received, which will help you in case of checking the real idea, the real world idea, the real patentable idea, and how you can protect your business or your idea with that specifically built AI tool. My tool, our tool. If you like this idea, this way, how we can follow on, just give me a nod.
Yeah, I shared my screen, and I will do what? I will move FITTIN.dev to that screen.
Okay, it works.
And let me just make sure that this is the screen that's being shared. So share again, desktop tools, okay, share. So switch on my audio. Okay, good thing. Good stuff. Let's wait for a minute till everything loads.
And you, Jose, unique, do you have an idea to check? Something like a very organic. Like,
Well, now that we're talking about it, I wonder if we can patent some SEO.
Because I
Services.
I have an SEO agency, and I know my services are something that I can't really patent.
can you describe it in a very short sentence?
So the agency provides SEO services for businesses.
Let's do it. Click the button, start free IP analysis, and click speak your idea on
Okay.
your,
You know that.
your computer. Yeah. Yeah, and start your speech.
I have an SEO agency, and I would like to patent the formulas and the workflows that I'm building with AI that I'm currently serving with my clients to other future clients. Can you look into that for me?
Click the stop button, the center screen, and transcribe to text. Okay, it get it. It got it. And submit for IP analysis. Just click the button. Please read it carefully. Is it your idea? Does it support? Does it make any sense?
Yes.
Well, down below you have the another button. Please go down below. Okay. Confirm and start analysis. That's easy. And in a couple of minutes, we will see the miracle. The idea will be checked. So right now it's working with the specifically built legal attorney inside.
Attorney agent.
Yeah. And yeah,
The SEO agent.
pretty much it's for free. It's for free. You can try other idea.
Free for users. You gotta pay for tokens.
It's free for first idea check.
Okay.
Okay. For example, if you need much more comprehensive idea check second time or other day, it will cost starting from $10 per idea. It depends how massive it will be, how massively it will be checked, up to $99 for a very complete corporate, level idea check. But for many founders, 10 idea check is just fine.
Wow, nice. So any founder who is building a startup right now and is worried, like not worried, but wants to get an investment, for example, and he thinks that he has a serious moat, which is patentable, pretty much what those guys can do is instead of hiring $100,000 retainer lawyers, or doing the research themselves, or writing their own AI agents to do that, and spending maybe, let's say, a few weekends on that, instead of just paying you $10 or $99 on FITTIN.dev, and get that breakdown of whether the idea is patentable and what steps are next.
Correct. And
Within a few minutes, what we're seeing right now.
And it will lead you towards to a very specific decision on your end. Either you will apply, for example, for a professional USPTO application, or you need to think around the idea second time, and you can create another hypothesis because you have some risks with that analysis occurred. You have some, for example, vague, on your idea and vagueness, and you need to make it more specific, more business oriented, more customer oriented, whatever. So it will help you to navigate yourself around your business ideas and around your feature ideas. Even once you are having business already, you can protect some of your features, not the business as a whole thing.
Okay.
Look, you have a button. You can open.
Okay, one
No,
second.
you can open.
Yes,
View
yes.
your analysis.
Yes, 1 second. I gotta find that screen. Yay. Mouse. Oh, yeah. Okay. Okay.
You're in Inception on the YouTube.
Yeah. And here you can open the full report from here. Open full report, or you can type in the email address.
Open the full report, as you can see. No. So should you patent this? Yes, but only after the provided formula is more position saying to specific technical steps. Okay, one defensible moats is not the most protectable element is not AI for SEO broadly, strong angles, specific coordinated workflow. Current competitor search data, keyword, okay, yeah. Okay. Should be, patent versus trade secret, file only what can be described as workflow sequence data, linkages, recommendation outputs, update loops. Okay, do not publicly disclose before filing, do not publish demos, agency case studies. Well, that's already too late.
We did our live YouTube today on this specific idea, right?
Yeah,
Partially.
because I see it's just conflicts, because this is how I acquire customers, is by me sharing how I do everything.
But you have shared pretty much an obvious idea. So
Yes, it's nothing proprietary, and why I've never. But the only part would be the tool that I would build with my strategy. That would be something, but because I don't have a tool yet.
Well, and it will help you to create a tool in a secret lab on your end afterwards. But this reading, I believe, consists of many different advices and approaches which you can lead, follow before even building the tool, before even building the business. And look at the list. It has, I think, a number of different paragraphs in that regard.
Yes.
Technical problem being solved. Addresses a specific technical gap in SEO workflow automation. Often provides separate keywords metric, page audits, competitor snapshots, backlink reports, and AI-generated content suggestions, but do not necessarily operate as a single adaptive process. So making it into one single process could be patentable in this regards.
Yeah, because I don't, it's how you package it. For example, one idea that I want to do, and a few people are watching already.
But
Okay, they dropped off.
Even right now, you are pretty much protected because it is like a prior art thing. You have been mentioned many things firsthand, being open, and it is a part of your disclosure.
So in court, you'll say, here's the YouTube live video dated where we came up with this idea.
Yes.
And they think looking like a very protective layer for any founder. Once you have applied to check your idea, you are following with the help of a platform our embedded non-disclosure agreement and some sort of legal documentation, and it protects itself, the founder's idea, organically based on the platform engine.
I think your product is very much needed, because this is, as people are creating several products, websites, a lot of things.
Yeah.
Definitely this is.
And any of your idea can be searched by this way. And please go follow down below. Go down below. It will. I believe that it will find other competitors with their patents already issued. In that regard, it will show you some risks after.
Is it giving ideas as far as what tools I can build? Is that what it's doing?
Pretty much.
Because I see it says like AI backlink. So it also gives you ideas.
It gives you ideas based on your original one.
Okay.
This is a full packaged studio. You come with an idea, and then you patent it for $99. And then for a few 100,000 tokens from Claude Code, you build it. And then what do you do?
For example,
You just gotta find someone to sell it to afterwards. That's the biggest concern right now.
this is the very first document about the patentability of the idea. But once you decide, for example, to dive deeper, you can ask the system to create 6-document portfolio. It is patent lawyer kind of level portfolio documentation, and the one of these 6 documents will be the specifically built draft of your future application. If you agree, you can draft and build your idea with the help of this platform for example, $65 to apply for provisional provisional application USPTO in one short move. Check your idea. If you like the description, take the draft. If you like the draft, you can apply, for example, by yourself, with not necessarily having a patent attorney to protect your business with $65 mandatory fee to USPTO.
And I see the examples that you have here of other people. Landscape signal, strong forms.
So it is very determined thing. It is not hallucinating in many regards. So it just orchestrating what I have been explaining you. It is orchestrating many other sources of information in a way to provide you with a specifically built document regarding on your based on your idea.
Look, you'll be competing exactly with the tools that you've been using so far.
Yeah. And another one and very powerful thing, right now you can take this document using your Claude, for example, or using your codex, and you can make your own research because it
gives all the
gives
context.
all kind of prompts to your system to navigate your system around your business idea with the help of this progress.
This is a very encompassing review of the trademark application. I don't think you can get that from a lawyer on the first visit.
And yeah, starting from now, we can follow this specifically built document, or we can check other ideas coming from other of us. For example, Nick can make.
Nikolai, do you have any ideas for patenting anything?
You know what, so I'm trying to fit it into my project, and I think that I'm trying to find a way what kind of services I can provide right now to customers. So I think that it's about that kind of customers, like it's for customers that building their own products. So I'm trying to align with my own company. So, and it seems that I don't know how to apply it because I don't have any. I'm not building products, so I don't have any. But
probably you like some ideas you've heard before over the routine conversation. Probably you have some ideas from internet, from I don't know, from other sources of information. It can be checked just for an example.
For example,
What do you interest for?
Like for example, an AI platform, and my friend right now building AI platform, and I think that it might be checked like no ETA. So how to try to can we check it?
Let's see.
We can check it. Yeah, right now we have used our free trial, and you can open your computer, FITTIN.dev, because you have a very different device, and it will be another free trial open.
FITTIN.dev.
And here, please to save the account, please type in Jose's or yours email address, and the documentation will be delivered exactly to your email box.
Click share screen, mirror to Smart 4K.
Yeah, sure.
Or
So I'm trying to set it.
yeah, I understood.
I don't know. It is yours or the computer, or it is.
It's mine, yes.
It's yours. So you need to take Jose's email
I
address.
understand.
Okay.
So
What I'm talking about, Jose,
how can I
please
share my screen?
provide the system with your email address.
Yes.
And it will deliver to your email box. Come on to Bluetooth, where Bluetooth is, to the right top settings. And send. Just
And then there is mirror screen.
No. This one, right? Or Smart G. Okay.
the Smart 4K. And enter.
What it is?
And then submitted ideas. And I have an IP document.
Pair, cancel, what it is. Pair, enter.
Yep.
Are you good?
Yep.
Now you're good. Yeah. Now you're good. So this is your patentability analysis. You can open it with the open button. It's your data room. Whereas your personal data room. Nobody can enter this these data room that you right now it's opened on the Ascat's computer. But once it will close, it will be not open again. With only with your code.
Yeah. Okay.
Do you like
Something. Yeah, something to, no, I think it's very important. Obviously, right now, I still don't have, a use case for it because I don't know what exactly I'm patenting in SEO. It's just an idea. I know that it's certain like workflows, but I don't know exactly what. But it's probably more something packaging together what I currently do.
Approach, my personal approach. Once I had a number of
Can you
things.
describe the idea?
I'm an inventor, an actual inventor here.
Yeah, let's do that.
I have invented many other things, and I have
While you do that, and
long stories.
just concentrate on other stuff.
Around the legal process itself.
So,
And what I'm doing, especially with this my product, I'm leveraging my
can you
cloud, for example.
So I'm trying to get
touch the teeth with a number of layer.
So yeah,
Right.
yeah, you need to remove.
And once you just say to me like, well, not bad idea. Well, you can try. You can try to do it next time. I can take this short description from my hub to the system, and if you create the specific review with the documentation under the AI generated edition.
Oh, I see.
Okay, I'll show you.
Yeah.
And it's Swift, so it's so organic and so natural. You don't need to invent your idea, to describe your idea with many other things. It will be created by the system based on the approach, general way.
Yeah. So I can help you with. Yeah, and as mentioned, I think it's important because this is why.
Well, you're going to create your story. So that's a trick. That's a very specific layout. And let's try the story. It will be nice. It will be nice.
So I'm just speaking, right?
Yeah.
Okay. So, well, it's an AI platform for traveling. It's not that type like Expedia or Booking.com because they're more like a legacy platforms because they have their really huge stack of customers and they don't want to lose them, so they're pretty cautious about implementing AI tools. They're implementing, I mean, but not that bold. And that platform is AI powered like a kind of customized platform for traveling. And we're using our private AI platform. We built our own model, and this is the base. So we're not taking resources out from different platforms like Anthropic or OpenAI, and we try to make it super customizable, and it's kind of advisory, the same company. And what else? Let's say like Spotify, but for traveling, so it's pretty customizable. So yeah,
But you stop.
it's enough. Like
Transcribe.
Yeah. I didn't give a lot of details.
It is kind of a different product inside of the platform. You get it intuitively. It is for mass market, like creating your business story first hand based on your idea with no necessarily having the patentability analysis from the scratch, but having a very nicely built story over your story to help you understand what you are talking about. Yes.
Yeah.
So,
I
get my
understand.
story.
Okay, get my story, okay. You.
Okay, and you have a code, I hope. It is like a protection.
Yeah, I understand it.
And confirm and get my story.
So now.
This is your data, your personal data room already built. And your first idea will be in this data room or ever.
Mhm. But I think that it's better to come up with more details, right? The more details you will provide, the better outcome gonna be.
Not necessarily. Not necessarily. If your idea is vague initially,
Mhm.
it will build some standard fundamentals under your
Mhm.
idea, taking it from the IP world, because this system organically connected to many sources of data of the specifically built businesses idea and patents
Mhm.
already exist in the world, and it can navigate anything new around the global world of ideas.
Mhm. Mhm.
Okay.
Yeah, gotcha, yeah, so,
Open your story, please.
yeah, sure.
And well, that's your story.
Wow.
And read it
Nice picture.
carefully. I hope it. I hope it reflects what you are talking and what you are thinking about.
So, yeah, it looks.
Uh,
detailed, so
we
I-
will do it a little bit later. This is the banner it offers to check your patentability. That exact idea is it patentable or not.
Mhm.
But we can do it later if you like it. What are you asking?
So, well, yeah, it looks like great. I'm reading everything, but you know,
It's not too long. It's not too long. The future of infinite adventures. Does it make sense?
yeah, so I'm trying to figure out. So here, like, uh, we have a button like for this platform, right? For traveling platform, and how it can help me actually. I'm reading text, like it's a really great narrative, but
Nice.
yeah,
Go down below.
yeah,
Go down below. Once you like the idea, it shows you how you are protected and why. It's just a law thing, you know. Go down below.
mhm.
And is your idea patentable? Get the full IP analysis.
Okay, that's
Click
great.
the-
But story was wonderful. Like I was reading through the text and I was like, wow, for sure. Like I didn't have that much words to describe like all the project, but it has.
But now the system has, and it transfers from the initial idea into the patentability check.
Mhm.
So right now you just need to submit your analysis for free.
Okay.
You don't need to speak it out again. it is the newly built layout for patentability analysis, like an extended of the story extension.
So right now I need to confirm and start
Yeah,
analysis,
yeah,
right?
yeah. If you agree,
I didn't spend a lot of time reading that text story.
but I think you
How can I, like, can I download it, like, to check out?
sorry.
Can I download it, like, all this stuff that I'm have as an outcome right now? Can I have it, like, those as a report or something like that?
The system has your email address, and you have the data room, and you have two ways to have the documents. Once you have data room, you can download it from data room, or your story should be in your email box.
So
Right now, you can check it. And the next patentability analysis will be delivered to the same email.
great, yeah, now I have it, see. Yeah, so that's great.
And you see down below, I'm developing full idea. For example, you can open your present idea, view full idea. Not now. Just let system work with the patentability analysis, but for later. You can open full idea. You can open your story from here, from down below. This is your data room. And once you will be searching for other ideas and other hypotheses, it will be having many of the different stories one by one.
So it's cool, I understand. So for example, right now, like, I'm pre-seed level startup and I'm developing my idea, like, I'm very different ideas. I can pay like from $10 to
Yeah.
99 and check out
Yeah.
whether it's a great idea or like, I'm just wasting my time working on that, right? It's great. Yeah, I think I understand.
And for startup founders, we have a greatly built tariff for $99. You can have 5 of your idea check, and afterwards you will choose the brightest one, and it will deliver you the full legal attorney level 6 document analysis as for the founder, checking exactly the idea you have been choosing among these 5.
Gotcha. Thank you for sharing that. Yeah, that's great.
Or you can just check your ideas one by one for $10, $10. How many?
Thank you.
Thank you.
Session.
Did you like it?
Yeah, thank you. See you tomorrow.
Thank you very much for your feedback.
Yeah, sure. So we'll see you in touch.
See.
And let's see in a moment. Look, it is almost ready. Before it is written, we have an embedded audio briefing inside, so you can click the button down below afterwards, and it will deliver a beautifully spoken story, like a podcast based on your idea.
That's interesting. It's like audio file, right?
Yeah, it costs like $1.99, and it will be created automatically once the idea is yours.
Oh, that's great. So now I'm opening it, right?
Yeah, opening. You can do it either way. Download. The answer to your question. Download. You can download it for later. For later. Right now, you don't need to. It is your room. So, but the patentability is not necessarily open. Please read it carefully because it is crowded private art zone, and it shows you why and how the landscape, the industry created the same patterns in many different ways before you start to think.
Yeah, I understand. Yeah, I see. Should we pattern this? Yes. So yeah, like recommendations with explanation. Yeah, that looks great.
But the document of the system will caution you to patent not the obvious idea, but patent some tiny things like more. And that is why it is written.
Gotcha. That's great. That's great. Yeah. So.
And please, it's interesting for me. Go down to how many patents it found.
So where is that?
Oh, whoa. Here. So prior art, landscape, and novelty. So many other references are here. And company names and their patents. And starting from now.
So it's competitors, right?
Yeah, it means, in general, it means that a part of your idea have used by many other companies, not the whole thing, not the whole chunk of the information, but some of the important parts are patented by other companies. All these patents are different. All these patents are kind of non-similar to each other. But right now we have a full list of information to search the specific information regarding your niche service, for example, on the market, to protect this very niche, to protect this very business against of your already existing partner or competitors, contenders.
How do you this data? So where from, like, what's your source to understand it?
So in my world, there are many specifically built databases. Many of them, of course, not for free. It is for legal attorneys and services and etc. For USPTO officers, etc. But once I'm in a business, I have connected to many of these sources of information. For example, towards the official USPTO database, which has every patent in the US, inside. Or, for example, EPO database, which has every European issued patent inside, or anything like that. So, and many other things which are determined, which are specifically built for years by other companies. And we are analyzing on fly many other things, but because of your initial idea. That is a uniqueness of the approach. How to lay out, how to orchestrate many other different and non-cheap to use things for free for our customers to provide you with a specifically built analysis.
Oh, that's great. Like, I can trust this data, right?
Yeah, data is determined.
So
you can check these numbers. These numbers are real. With ChatGPT, for example, or Claude. I don't know. Here you are. The same inventor, the same company, the same patent.
Yeah, it looks real. Looks real. Yeah.
No, because these data comes from real sources.
Real-time feedback, revised so and there are advantages also here. That, yeah, it looks interesting. Like I'm gonna show it to my friends that work in the platform,
Mhm.
and interesting what they're gonna say.
It has been built by my team here in San Francisco, so it's organically our platform for Bay Area residents, for founders.
Yeah. So is there something interesting in this? Like,
Go down below, please. Oh, look, clone analysis. It's interesting sometimes. Clone, just little bit. So it shows how easy or not easy they, contenders or clones can copy the idea if you have, for example, been started that type of a business. It's kind of a caution.
or it's great for businesses, right?
Mm-hmm.
Really interesting.
And this is just a free of charge analysis. Once you will be applying for a full 6-document analysis, it will be much more complete, much more complete. It will be a huge reading. Like a business, documentation, full stack for your business in many regards, regarding the risk analysis, regarding the competition analysis, regarding the market analysis, kind of even price analysis, many other things will be involved. Ashat?
Yeah, it's interesting to read. Yeah, thank you.
You're welcome.
So
wrap it up.
Yeah, that's pretty much it. And this platform just shows as an example how easy you can start your way to protect your business with a couple of clicks in a couple of minutes. You not necessarily spend your money and hours of your time with the patent attorney, for example, firsthand.
Yeah, definitely. When you're building your own platform project, definitely. I think that it's a great service.
Mhm.
Yeah, thanks for watching.
Thank you. Thanks for watching. Thanks for having me today for this session. It was, yeah. You can visit our website FITTIN.dev. It is open. It's free for your first idea check, and enjoy.